has moved the Supreme Court against Jayalalitha's acquittal in the disproportionate assets case. Jayalalithaa was acquitted, remember, by the Karnataka High Court in May, paving the way for her return as Tamil Nadu Chief Minister. Now, this comes as the Karnataka Cabinet accepted the recommendation of Special Public Prosecutor B.V. Acharya and State Advocate General Ravi Verma Kumar to appeal against the May 11 Karnataka High Court verdict. Now, the special leave petition on behalf of the state of Karnataka in the Jayalalithaa disproportionate assets case has been filed today in the Supreme Court. The Karnataka state government has prepared a lengthy, over 4,000 pages appeal against the acquittal of the Tamil Nadu Chief Minister by the Karnataka High Court. The DMK has already filed a special leave petition before the Supreme Court against the High Court's verdict. The High Court had reversed the conviction ordered by the trial court on the 27th of September last year. The trial court had sentenced Jayalalithaa and 3 of her associates to 4 years in prison and imposed a hefty fine of 100 crore rupees on her and 10 crore rupees each on her associates Sasikala, Ilavarsi and Sudhakaran. Now, the High Court delivered its judgment on the 11th of May and Jayalalithaa became the Chief Minister for the 5th time on the 23rd of May after her acquittal from the High Court. All right, so those are the details that are coming in at the moment, with the Karnataka government having moved the Supreme Court against J. Jayalalithaa, the Tamil Nadu Chief Minister, in the disproportionate assets case. This comes after the Karnataka High Court had, of course, acquitted J. Jayalalithaa in May this year, paving the way for her to take oath as the Chief Minister of the state for the 5th time. Rohini Swami is now joining us with more details. Rohini, how confident is the Karnataka government that a case that they had lost in the High Court may be reversed in the Supreme Court?
They definitely they're very confident about the SLP, the special leave petition that they have filed, saying that they have gone ahead and done that because they do find a lot of lacunae in the judgment that has been delivered by Justice Kumaraswamy in the Karnataka High Court, which led to the acquittal of Jayalalithaa and her associates. When I did speak to Advocate B.V. Acharya, who is the Special Public Prosecutor in this case, he said that they have been going through the entire judgment and they have found that they have a lot of faults which can actually be, which have been overlooked. And that is those are the points in which they have gone ahead and filed this special leave petition in the Supreme Court. They feel that, like the lower court judge, Justice Michael Vicuña, found it a watertight case against Jayalalithaa, they too think it's pretty much a watertight case against her, even in the Supreme Court.
All right, Rohini, stay on with us. We also have with us our correspondent Anusha Soni joining us from the Supreme Court. Anusha, this CLP is being filed by Karnataka government. The DMK has also filed an SLP, in the case. So, are these two cases going to be looked at separately, or since they pertain to the same matter, is it likely that they'll be heard together?
Well, we'll have to wait and watch how the court takes the approach forward in this case. As you rightly mentioned, both of these petitions have been filed separately. But the key point to note here would be, what is the connection between these two SLPs? What are the key grounds on which the Karnataka government is taking this step forward? Remember, as you said, that there is a lot of lacunae in the judgment of the Karnataka High Court, and it has been widely criticized by the leading, legal barons and the lawyers, saying that it was bad in law in many ways. However, it is yet to be mentioned at a bench before the Supreme Court. We are likely to hear very soon as the Supreme Court resumes its full-time working in July. That's when we'll know what exactly is the thrust of the argument of this case, and how is it that DMK will respond to it, because that's how both of these are going to be heard in conjunction with each other.
Anusha, take us through some of the highlights of the arguments that were placed in the Karnataka High Court, basis which the Karnataka government feels that they can use some of those arguments and perhaps put a stronger case now in the Supreme Court, since they'd lost that one.
Well, one of the very interesting facts that was raised in the Karnataka High Court judgment was the quantum of the disproportionate asset. So there was this entire debate about what quantum can be a disproportionate asset. She, of course, Jayalalithaa has a very high stature in Tamil Nadu, and she's revered by and worshipped by many in down south. But exactly what constitutes a disproportionate asset? What does it take to establish that someone has disproportionate asset? Does say 150 pair of shoes or many dresses or saris? These are all the arguments and interesting arguments that were raised in the case that time. And of course, the way Karnataka High Court, the approach Karnataka High Court took to all these arguments was criticized by many, primarily on the definition of something called the disproportionate asset. Because you understand, we are dealing with a case which was filed 20 years ago.
Yes, absolutely.
Right? So the value of the money, the quantum of the money, all of that has changed over time. And of course, this is a contextual argument that one will have to look at.
All right, Anusha, many thanks for putting those arguments into perspective for us.